Hello, and welcome back to Emmy Law's YouTube channel, your go-to source for valuable insights on legal matters. My name is May. I'm your host, founder, and principal lawyer of Emmy Law, and today we're going to be discussing the art of negotiation and finding a resolution in corporate lawsuits. In corporate lawsuits, the art of negotiation plays a critical role in finding a resolution that is beneficial for all parties involved. Whether you're a business owner, executive, or legal advisor, mastering the art of negotiation is essential. A negotiation structure typically has 5 elements. The first element is you have the planning stage, what you need to do to prepare for your negotiation. The second element is you have the discussions, where you need to establish what's on the table at the negotiations. The third element is you have the proposals and concessions, where the main negotiation happens. The fifth element is an agreement, where the final terms are finalized. And the fifth element is making it work, putting negotiation solutions into practice. Here are some key strategies for successful negotiations in corporate lawsuits. Most people focus on 3 central stages, but spending more time planning, you can put yourself in a stronger, more confident position. There is a tendency for people to overlook the fact that the end of the negotiation may signal the start of an ongoing working relationship. You should always have consideration for the long-term impact of the negotiation and the influence it may have on concessions you agree to. You have to prepare thoroughly. Before entering into negotiations, it is important to prepare thoroughly. This includes understanding the legal issues, knowing your objectives, and researching the other party's position. You need to answer questions like, what are your objectives of the negotiation? What are your priorities? What must you achieve? What would be great to get but wouldn't be a deal breaker if you didn't get it? And what will your negotiations be with? What are you negotiating about? And what's on the table? Where do you start? So when you look at all of that, you have to answer all these questions when you're preparing, right? The next stage is that you have to establish clear goals. You have to set clear and realistic goals for the negotiations. Define what you hope to achieve and prioritize those objectives. You also have to build your repertoire. You have to establish a positive relationship with the other party. When you establish positive relationship with the other party, it can help you create a more cooperative atmosphere for negotiations. Listen actively, show empathy, and be respectful. You also have to adjust yourself to the people that are in the room with you. Sometimes you have to negotiate with legal advisors. Sometimes you have to negotiate with controllers. Sometimes you have to negotiate with union representatives. So there's various different people within within this sphere that you need to negotiate with. So it's important that you cater that negotiation to that specific person, or you cater yourself and your communications to that specific person. You also need to turn your mind to what I call the balance of power. You need to understand that the most important thing about negotiations is where the power lies. This is who has the power in the negotiation. What form of the power this takes. Once you understand that, then you can use it for your own advantage. To look at who has the balance of power, you need to determine how to use that to help you reach a mutual beneficial agreement. So now what you need to do to understand where that power lies, you need to look, for example, at the size of the corporation you are negotiating with, and whether you offer something that others do not offer. For example, let's say you have a product or skills that is a niche, right? That is your starting point. You have the power in that product or skill that you can offer. You also need to look at the current market. Does the current market condition benefit you? Again, that's something you can use in your power balance. You need to also look at things like knowledge, time, brand, reputation, status, title, and location. All of these factors are very, very important in determining who holds the power and at what point do you hold that power. Is it going to be you? Is it going to be the other party? If the other party holds some of these things for example, some of these things are beneficial for the other party, then you need to work around that. How do you work that into your grand scheme of things if you're trying to negotiate better terms for your side? All of these are really important in determining where the power lies, like I mentioned, and how to use those, again, for your benefit, right? So it's important that when you approach negotiation stages that you really unpack everything. It comes down to bare bones of things, and then you fill those bare bones of the stuff you're looking for with information. Then you need to focus on interests and not just your position. Instead of focusing on your position, focus on your interests and the underlying needs behind them. This can help uncover common ground and create solutions. You also need to explore options. You need to be open to exploring different options and alternatives for resolving the dispute. Brainstorming with the other party can lead to innovative solutions that benefits both parties. So it's not just you, remember, at the table. You have another party at the table. You have to understand that the negotiations are you working with another party. So you have to be able to brainstorm ideas. So you could come with an idea. You can come with what you want. And, most likely the other party does not want what you want. So you need to be able to say give and take with the other party and so forth. As part of negotiations, you need to be flexible. Negotiations, they often involve compromise. So you have to be willing to make concessions in order to reach a mutually acceptable agreement. Some things you might want and some things you might not want, you're okay of letting go. So it's important to have that flexibility. You also have to communicate clearly. Effective communication is key to successful negotiations. Clearly articulate your points, listen actively, and seek clarification when needed. You need to look at how your discussions are going during negotiations. You will want to ask questions. Your questions should be open. Your questions can be closed. And you also want to ask probing questions. You also want to recap your discussions, just so that the other party knows that you're listening to what they need, their wants, what they agree with, what they don't agree with. This also helps you narrow or understand fully exactly what it is that the other party wants. The proposal and concession aspects of negotiations allow one side to make a proposal, and you have 4 options to either say no, yes, I need to think about it, and let's adjourn it to a later date, or you can make a counter proposal. It's always recommended that you prepare for adjourning or making a counter proposal. If their proposal doesn't work, your proposal doesn't work, it's always beneficial to come prepared with a counter proposal offer. That way, you tried everything at the table the first time. If you have to think about it, you can always come back and adjourn it to a later date that works for all the parties, to think about a proposal. If you also want to go back and fine-tune certain things about a proposal and come back with whatever they propose with some additional terms, etc., you could do that. But it's always recommended that you do that in advance, right? So that you get more out of the day or more out of the couple days that you're negotiating for. If you're a lawyer, I recommend you can do additional training in negotiations. Just because you're a lawyer doesn't mean you have to stop learning. Lawyers by trade, they should be able to negotiate certain client positions. But when you're actually negotiating contracts and deals, and maybe you're dealing with negotiating some sort of dispute, like I mentioned, you should have a little bit of additional skill training in your skills. There are law schools within our jurisdiction, for example, in Ontario. that offer continuing professional development courses and certificate programs in negotiations. And I'm pretty sure that it's across the board, across all over Canada, where certain law schools will offer certain negotiation, continuing professional development negotiations, not just open for lawyers, but for individuals that work in areas that allow them to, professionals who work in areas that give them the ability to be part of the negotiation stage. They do take additional training for that. The final stage in coming to an agreement, which is the final stage in negotiations coming to agreement, the agreement might take time to work out all the details. So you might come to negotiations, decide what you're going to do, then that's implementing into an agreement. So it might take time to put together an agreement, whether it's a mutual release on terms that you've negotiated for, in reference to a lawsuit, or it's terms in agreement, getting a job, that job, and so forth and so forth. It needs to be put into an agreement. So that is a step in the right direction in order to make things work. And now what has to happen as part of that agreement, someone has to say they're willing to do the agreement. So you might want to be the party to say that we would put together the agreement. It might give you the upper hand. Same thing with mutual release. Same thing with terms of settlement. Just if you're the party doing it, you might be able to put in the terms you want. The other party reviews it, and the back and forth can go in terms of removing words or adding words and so forth. Now, you need to also seek legal advice. If you don't have a lawyer as part of this negotiations, you do need to seek legal advice in complex corporate lawsuits. For example, you need to go negotiating terms. It's advisable to seek from a qualified lawyer. That's my advice to you. That's what I'm saying. It's advisable to go to a lawyer to get this type of advice. A lawyer can provide you guidance and legal aspects of negotiations that can help you navigate the process. It's important that you go speak to a lawyer who has the skills in negotiations, who've done it. I think not all lawyers have negotiated, not all lawyers have mediated, not all lawyers have arbitrated. They don't know the process. They haven't been, even though they do civil litigation or they work in the civil litigation industry. That's why I suggest that it's important that you get the training if you haven't done so. But it is recommended that you speak to a lawyer. Remember, today's advice isn't legal advice, or today's information isn't legal advice. If you need personalized guidance, reach out by visiting our website at www.melaw.ca. If you also enjoyed this video and found it helpful, don't forget to give it a thumbs up, subscribe, like our video. We try to get important, insightful legal content out there on a weekly basis, almost on a daily basis. We appreciate your time and look forward to seeing you in our next video. Until then, take care.